Please note that this content is for educational purposes and for adults only. Viewer discretion advised. More details available in the description box. Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we continue to look at Madeline Soto's case. We haven't spoken about her case for a few months now. There hasn't been any big news or something, but now, oh my word, the trial, his first trial, is approaching. I say it like that because we got to put those dates in pencil. I never quite believe that it's really going to happen as soon as they say it is. I hope so, but you just never really know. So I'll tell you all the trial dates and everything in a moment, but yeah, wow, his defense has just filed a lot of motions, and I'm like, oh my word, are they trying to get a delay or a plea deal? You know, because it's a lot more than I've seen in other cases. Not that I'm a lawyer, I'm just like, damn, there's a lot of motions. So don't worry, we're gonna go through the highlights of all of them, okay? And we're going to do a little recap as well. So welcome everyone, welcome to my moderators. Thank you so much for everything you do. Wow, everyone, there's a lot of people here celebrating their milestones. Here's Arizona Gal, thank you so much. Welcome to all my members. If you are on Patreon, today we had our very first Patreon premiere, which was so cool. That was so much fun. So thank you to everyone who was there, and you got to see what I recently invested in. So thank you so much, I really appreciate it. And welcome to anyone who's new here as well. Remember, subscribing is free. If you just hit the subscribe button, then you're a Grizzly. Because some people think they have to become a member or patron to be an official Grizzly. No. You just hit the subscribe button and we're there. Please like and share so others can also learn about these updates and this information. It definitely helps, you know, if people want to know, well, what are the charges, when is the trial, what's happening, what is this case about? We can't just assume that everybody knows about the case. I did see a comment, I think from Mimi earlier, saying, you said, I so wish that we didn't have to put, you know, him on the thumbnail basically with the victim. And me too, but unfortunately this is social media and we have to kind of spell it out for people about who's the case about, you know, so that new people can also find the coverage and actually learn about what happened here, because it's absolutely horrendous, right? Okay, so first what we're going to do is a little presentation time. I've obviously got a picture here of Madeline Soto. She was only 13 years old when she was allegedly murdered. So, and her case does come with a trigger warning. It's extremely sad. It involves sexual abuse, murder, topics like that. So if it ever gets too much for you, please know that we will always save you a seat. Make sure you look after your mental health. Sam's mom, for 19 months you've been a member. Thank you so much. My goodness. Okay, so check this out. Let's bring the presentation up here. Okay, so just a quick recap as well. I find a refresher is always good, especially when we haven't spoken about the case here in this community for a while, right? So, okay, Madeline Soto, it was Thursday, February 22nd of 2024 when she turned 13. And then on Sunday, February 25th of 2024, she had a birthday party at 3 p.m. to approximately 8 p.m. and that was at her grandmother's house. That was her last day alive. It's like, you can't even, I mean, it's bad no matter what day it is that she was murdered. But like, she had her birthday party and then she was murdered. That's crazy. I can't even, my word. So she had a birthday party from approximately 3 p.m. to 8 p.m. and then she was dropped off at home by her aunt at 8:30 p.m. and Stephan Sterns, her mother's ex-boyfriend. I always correct that because he wasn't really the boyfriend at the time. He'd actually moved out. They'd broken up, he'd moved out. So what the hell was he doing there? Anyway, the ex-boyfriend arrived at approximately 8:45 p.m. and Madeline and Stephan, the ex-boyfriend, was sent upstairs to go sleep upstairs at 11:19 p.m. because Madeline's mom said she just needed a good night's rest. That is unacceptable. I will never stop saying that. Don't do that. 1, be very careful who you let into your home, especially around your kids. 2, do not send them an ex-boyfriend. You know, this 37, 38-year-old man, you're going to send him upstairs with your 13-year-old. No. Definitely not. Giovanna, thank you so much. So yes, put your snarky pants on, everyone, because this case, it's very upsetting. We're probably going to get snarky, even when we see the documents. Even that I know that this guy is innocent until proven guilty. I do not need to be schooled on that. But I have a job to do, and that's me as a YouTuber. And I'm making commentary here while covering the case, and sometimes I might get a little bit snarky because I'm protective of the victim, which in this case is Madeline Soto. And what happened to her is just absolutely horrendous, and for so long in plain sight, right? I'm just going to pop your milestones up on screen, but thank you so much, everyone. I do see it. If I miss one, I am so sorry. Okay, so police reports say that they believe that Madeline was deceased when she was removed from her home, and at 7:35 in the morning, the next day on February 26th of 2024, on the surveillance camera, she was believed to be deceased in the vehicle that Stephan Sterns was driving. Her body was discovered on March 1st of 2024. So that's just some bullet points, a recap of, the timeline. But it's certainly, we've done much deeper dives. So if you want to check out the playlist, there's 69 videos on there. And we've done a lot of document deep dives, police video interviews, police audio interviews, and all of that, right? Okay, so what happened to Madeline? It is alleged that Stephan Sterns sexually abused Madeline Soto since she was approximately 8 years old. From like 2019. Sterns had over 1,700 images and video files on his phone, or his Google Drive account as well. CSAM, child SA material. And so I've just got a little screenshot there from the documents that says, on March 29th of 2024, I received the case synopsis from the medical examiner's office. Dr. Giles ruled the cause of death as strangulation and the manner of death is homicide. So that's, if you didn't know that, now you know that. Ange, thank you so much. Oh my goodness. So Jen, I think she's 37 years old. If somebody knows or wants to correct that, please do. But I think from what I remember, what I had checked on the files, I think she's around 37. Madeline Soto, forever 13, and she had just turned 13. And then Stephan Sterns is now 38 years old. Okay, and just look at him in that picture. I mean, this picture just says a lot. He's just like sneaky, worming his way into the home. It's kind of, we've recently been studying Naziah Harris's case, and looking at the strategies of groomers, and it's just so sad because Stephan Sterns was just like that as well. So what are his charges? So he's been charged with first-degree premeditated murder and sexual battery, 8 counts on a child under 12 and 5 counts with a child aged 12 to 18 under familial or custodial authority. And then 7 counts of lewd and lascivious molestation. Oh, and 40 counts of possession of CSAM. Stephan Sterns will have 2 separate trials. So they were initially going to have one trial, and then they decided to separate the 2. So it'll be the CSAM, the CSAM and sexual abuse charges will be one trial. That's the first trial coming up supposedly in February. And then later in the year in September, it will be the next trial, which will be for the first-degree murder charge. The maximum sentence that he will face for the CSAM and SA trial could be multiple life sentences. I mean, just for each picture, he could serve up to 5 years. So multiple life sentences. Wow. And then he faces capital punishment for the murder charge if convicted. And if you just look at that little screenshot that I took there from Court TV, prosecutors in Sterns' sexual assault case have not filed an intent to seek the death penalty case. A 2023 Florida law allows the state to pursue capital punishment if an adult is convicted of sexually battering a child under the age of 12. So as we all understood it along the way, it sounded like, especially because they were going to have one trial initially, and then they split them up. There was a little bit of confusion because I myself was saying, well, are they seeking the death penalty in both cases? And that's what was reported initially. But when I look now, it seems like it's actually, if he's convicted of the CSAM and sexual abuse charges, that will serve as an aggravating factor for capital punishment in the second trial. So that is what he is facing there, all right? I'm just trying to see what your comments are there. Diana Banana says, this creature makes me gag. Thanks for covering, G. Couldn't study without you. Thank you all for being here to study this case with me. So when is the trial? Again, write this in your diary in pencil because it is subject to change, especially, with the amount of documents that I've just seen flying out from the defense. I'm like, wow, pumping the brakes or looking for a plea deal. I won't be surprised, Anyway, so when is the trial? there's two trials, right? The first one, pre-trial, is February 12th of 2025. At the time of this live stream, it's February 4th of 2025, so that's just around the corner. The pre-trial hearing, right? February 12th of 2025. The trial starts on February 24th of 2025, and that's for 60 sexual abuse and CSAM charges. Trial number 1. The next trial, the pre-trial, is for September 10th, and that's the first-degree premeditated murder trial. That's the one where he's facing capital punishment if convicted, okay? And so the murder trial is set to start on September 22nd of 2025, as you can see there from the little screenshots from the court docket. Thank you so much to Grizzly Cat for also helping me confirm all of this and for helping me find all of these documents as well. Is his defense trying to get a plea deal? That's my question. When I saw all of this, I'm like, damn. You know, because sometimes if there's capital punishment that's on the table, then sometimes the defense would kind of nudge for a plea deal to be offered. So like, take the death penalty off and then he'll plead guilty. Well, I don't know. We'll have to wait and see, right? I don't know. A lot of people have emailed to ask me if we're going to be able to watch this trial. I don't think the February one. I don't think so, but I don't know. Okay, if you know, let me know. I just don't think, because of the nature of the charges there, that they're going to be streaming that. But you never know. The September one, I do wonder about that one. They might actually stream that, right? So, is his defense trying to get a plea deal? Stephan Sterns' defense have filed a series of motions, and it's many. It's like 20 new documents, okay, ahead of February's pretrial hearing, and are trying to have the death penalty struck because they say it's unconstitutional, which is why my mind goes like, okay. I mean, obviously, they have to fight for their client, but I have to fight for the victim, and I can get snarky about it, okay, here as a YouTuber, because I'm like, wow, some of the things that they're asking for, I'm like, okay then. They're doing the best they can, they're doing their job, but it doesn't mean that I can't get upset about it. And you might too when you see the wording of something like, what? Okay, so look at all these documents that have just been filed. Look at the dates. You could just see from the 31st of Jan, motion to declare Florida Rule of Criminal Procedure unconstitutional. Look at all these motion. You see what I mean? I'm not joking when I say it's a lot of documents. So I've picked the most important ones. However, if anyone feels like, what if we're missing out? Don't worry. I'm going to be posting the documents on my latest Patreon post, which is public, okay? It's free. You don't have to pay or sign up to look at those. You could just go to the latest one right after this live stream. I'll be posting the documents there, okay? There's another screenshot of even more motions. So it's like, it's so much. Now, the state's aggravating factors are for the death penalty, right? And that's for the September trial. Madeline Soto's age. Obviously, she was a minor. Stephan's relationship with her as an authority figure, and the sexual abuse that she endured for many years, which would serve as a prior conviction if he's found guilty in the first trial, February 2025. Okay, so that is why the defense is already preparing for that, which also tells me that they know there's a very good chance that the February trial will go very quickly and that he'll be convicted because they have pictures and videos. They have that evidence, you know? It's difficult to argue with that. So we'll have to see what happens. But if he's convicted of all of those charges, I mean, already you could spend the rest of his life in prison. Then he's still going to have to, in September, go on trial for the first-degree murder charge. And yeah, they could face the death penalty. So, if you didn't know, a memorial for Madeline was held at Peace Church in Orlando. That was on March 7th, I think it was. Some of her school friends attended. And Madeline's body was cremated, and her ashes are with her biological father, Tyler Wallace. Because people ask me this all the time. On the right-hand side, there's a screenshot from when the GoFundMe shared like a little snippet to say, Maddie, on March 6, 2024, our precious Maddie was laid to rest in a private service surrounded by family and close friends. Again, thank you for your support. So we have that. So that conflicts with a cremation, but I don't know. That's what they said. They had a private ceremony to, say goodbye to Maddie, which is, she had a whole life ahead of her. It's just so sad. And then I just wanted to read you this from her obituary, which says Madeline Soto. It's also written, I think, by her dad. Father Tyler Wallace. Okay, Madeline Soto, affectionately known as Maddie, was a shining light in the lives of all who knew her. With a deep love for animals, Madeline's dream was to become a vet. She had a gentle and compassionate nature, always showing care and kindness to the animals that she adored. Her favorite colors, green and lavender, perfectly reflected her calm yet vibrant spirit, a blend of serenity and liveliness. She was interested in makeup, as many young girls are. Madeline had a passion for music and enjoyed listening to Taylor Swift. She also had a creative side, often spending hours making beautiful beaded bracelets, each one reflecting her unique personality. Maddie loved painting and was involved in a door painting project at school. She won Student of the Week because of her contribution. Her love for volleyball brought out her fierce determination and competitiveness. On the court, she was focused and driven, traits that carried over into all aspects of her life. She also greatly loved swimming. Hiking, walking, and drawing by the lake behind the complex were some of her favorite pastimes. Thank you, everyone, for sharing the lavender and green hearts for Maddie. So Madeline's life was unfortunately taken on the night of her 13th birthday celebration. Her memory will forever live on in the hearts of those who loved her. She was a daughter, a friend, and a bright soul with so much potential. Though her time with us was too short, her impact will remain. Her love for animals, her creativity, and her laughter will never be forgotten. May she rest in peace. Shame. Oh my goodness. Now, what we're going to do now is look at some of these documents, and oh my goodness. Again, thank you so much to Grizzly Cat, because I was so overwhelmed with how many there are. I'm like, how many are there? Like, what is the total amount of documents? What is happening here? But we have here, I've got how many? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, about 15 lined up for you. But we're just going to look at what we need to look at, okay? State of Florida, plaintiff versus Stephan Michael Sterns. Yeah, if you didn't know his middle name was Michael, now you do. Motion to exclude evidence or argument designed to create sympathy for the deceased or vilify Mr. Sterns. Again, the disclaimer, I know the defense is just doing their job, okay? But wow, that's where my thumbnail comes from. You don't want to be vilified? I think you already are. You know, I know they mean in front of the jury, of course. But damn. Okay, comes now the defendant, Stephan Sterns, through his undersigned counsel, and respectfully moves this honorable court to prohibit evidence or argument during both the guilt and penalty phase that is designed or presented with the intent of or would have the effect of creating sympathy for the deceased or vilifying Mr. Sterns. Such evidence and argument are contemplated to include, but may not be limited to, that which details the impact of the offense on the friends and or family of the deceased, the impact of the offense on the community, the life histories of the deceased, or any personal characteristics of the deceased or of Mr. Sterns. In support of this motion, the defendant provides the following. 1. Mr. Sterns is charged by indictment filed on April 24th of 2024 with first-degree murder. So yes, that's the day when he was charged with first-degree murder, even though he was already arrested by February 28th, you know, and charged with all those CSAM charges because of what they found on his phone. Remember when we watched his police video interview together? And then they said, can they take his phone? Yeah, well, they took that and extracted a whole bunch from there, and it was horrifying evidence. I feel sorry for the detectives who have to see that evidence, you know. Number 2, the state filed a notice of intent to seek the death penalty on June 7th of 2024. Florida law has consistently held that evidence designed to create sympathy for the deceased is inadmissible in the guilt or innocence phase. The Florida Supreme Court reaffirmed this line now. Now they're just going to cite a whole bunch of obviously other cases. This is a 13-page document, and so they're backing up their argument. But I just wanted to show you that. You can read all of this if you want to. As I say, I'm going to post the documents for you. But you see, they're just backing up their argument here of why they don't want him to be vilified in the guilt or innocence phase. And they also don't want too much sympathy or no sympathy for the victim, which obviously is very, very sad, right? But I do understand. In court, I understand what they're saying, right? Okay, so they're backing this up over here. Let's just see. Yeah, that's pretty much everything we want to see with that document. Okay, then the next document, and sorry, something's just tickling my eye. I think it's like I've got a little hair on my eye. Yeah, there we go. Cat hair, always. Okay, every time I saw one of these, like the titles, I'm like, what? Here behind the scenes, I was gasping. What? Motion to exclude any and all victim impact evidence. Okay. The defendant moves this court to prohibit victim impact evidence because cumulative and powerful empirical evidence demonstrates that it is so unfairly prejudicial as to violate the 14th Amendment of the United States Constitution. Moreover, evidence demonstrates that victim impact evidence violates the 8th Amendment, specifically under Florida's capital sentencing scheme, which does not permit non-statutory aggravation to be presented. Finally, it is now clear that victim impact evidence violates that Florida statute because its probative value is substantially outweighed by unfair prejudice. Okay, so I think that would be, this is in preparation for the second trial, the first-degree murder trial, because there will be the guilt or innocence phase and then the punishment phase. And normally in the punishment phase, they would have victim impact statements there based on some of the trials we watched. I don't know if that's how it works here, but it would seem like that's the time to really motivate why he should be receiving capital punishment. And so they don't want that. I understand why the defense doesn't want it. We want it. Yeah, we want the victim impact statements in there, right? Rob McMullen is like, denied. Yeah, we need Judge Gold right about now. Denied. Yeah, Becky B says, oh, they're joking. I don't think so. And they're really throwing a lot at the wall right now to see what sticks, you know? Just, and it's like right now, just a flood of documents, obviously because the pre-trial hearing is about to happen soon. Okay, so they said facts. Well, here the state is presumably will announce its intent to present victim impact evidence. And here again, they're just citing all this law of saying why they don't want it. Okay, they're backing up with stats and graphs and everything of why they don't want that in. Wherefore, the foregoing reasons, the defendant requests that this court enter an order granting this motion. Okay, so don't show sympathy for the victim. Don't vilify Stephan Sterns. No victim impact statements. I'm like, no, I'm not loving this. Holly says, justice for Madeline. Gee, thanks for all you do and the mods do to address these hard topics in such a professional and sensitive manner. Thank you so much. That is so sweet. Thank you very much. Okay, so we've looked at that one. Then we've got this 4-page one. Motion to allow testimony of the impact of the defendant's execution of family members. So you see where I start snarky. I'm like, well, okay. So no victim impact statements, no sympathy for the victim, don't vilify him, but let his family speak and say why they don't want him to receive capital punishment. I'm like, okay, interesting. The defendant, Stephan Sterns, through his undersigned counsel, respectfully requests that this court allow testimony regarding the impact of his execution on his family members during penalty phase. As grounds, Mr. Sterns states the following. 1. The defendant is charged with first-degree murder, wherein the state is seeking the death penalty. 2. Should the case proceed to the penalty phase, the defendant intends to present testimony of family members. 3. Part of this testimony includes the impact of the defendant's execution on his family members. I mean, that's heavy. You know, for his family members. So I understand that, but I mean, Maddie is not here anymore to live her life. So, anywho, they said 3, part of this testimony includes the impact of the defendant's execution on his family members. And here they again cite a court case. They said the court held that it's properly cognizable testimony that the defendant's execution will have a tremendous negative impact upon the lives of his mother, father, and siblings. 5, trial courts have been willing to consider such evidence in very limited ways. Wherefore, the defendant respectfully requests that this court allow testimony regarding the impact of his execution on his family members during penalty phase. So what are we thinking? I'm just looking what you guys are saying. Yeah, Kay said the prosecution must be digging their heels in on the death penalty. Which I wonder if they'll say, okay, well, what we're going to do now is offer him a plea deal. How about you plead guilty and then we'll drop the death penalty? We could see that happening sometimes in a case like this. I'm not saying that is what's happening, but I won't be shocked if that is. I won't be shocked either way. I will not be shocked if this trial gets delayed. I will not be shocked if a plea deal is offered and if he takes it. Because, sure, the more of this information that gets out is more dangerous for him, if you know what I mean. For that prison justice. Once other inmates find out what he did to a little girl, wow. Allegedly. Of course, he's innocent until proven guilty, right? So Elizabeth, how do I say your surname? Duggett said Maddie didn't want to be where she is now either. She wasn't afforded an option though. I know, right? So do you guys feel snarky with me? Are we feeling snarky? Because I am. Letteros by Betteros said, always waiting for you to go live. I may be obsessed. Grizzly True Crime, the goat in true crime. Thank you so much. Okay, so I think that if his family is allowed to talk about the impact that him facing the death penalty will have on them, then I think there should also be victim impact statements. That sounds fair to me, you know? Because I think the jury would have to decide then as well. They would probably have to go and deliberate for a second time in the punishment phase to decide if they recommend the death penalty or not. So then, motion for transcript of grand jury proceedings. So here they said, comes now the defendant, Stephan Sterns, through the undersigned attorney and moves this honourable court to enter an order authorising undersigned counsel to obtain a transcript of the grand jury proceedings upon which the indictment in this case is based, and as grounds therefore states the following. 1. The defendant is charged by indictment with first-degree murder. The testimony, 2. The testimony, jury instructions, and notice of any physical evidence that was presented and upon which the instant grand jury indictment is based should be provided to undersigned counsel for the following reasons. To determine whether false testimony was presented to the grand jury, as shown by witness statements given during the investigation, depositions, hearings, and or trial. I mean, if I was the defense, I understand. Check all that. Some rain drops on Rosa, said the mother and daughter had been means to an end. Well, his target was clearly the daughter, which is very sad. And so they say here, to determine whether false testimony was presented to the grand jury as shown by witness statements given during the investigation, depositions, hearings, and or trial, to further justice by determining whether the grand jury proceedings were conducted in accordance with Florida's Constitution, laws, and procedures, to enable meaningful and intelligent enforcement and review of the right to a grand jury indictment. I understand this. If I was them, I'd also want the transcript. Let's see. You know, especially because there may have been some liars along the way. Some people change their story a lot, like the mother, right? Anyway, so they said to enable meaningful and intelligent enforcement and review of the right to a grand jury indictment guaranteed by 5th, 8th, and 14th Amendments to the United States Constitution and Article 1, Section 15A of the Florida Constitution. There is no justification for continued secrecy of the grand jury proceeding, and any justification advanced by the state does not outweigh the due process right of a defendant charged with a capital crime to be afforded his state and federal constitutional right to disclosure of what transpired during the grand jury proceeding. Okay? And so the disclosure of the above material is essential to ensure compliance with the federal guarantee of due process and indictment under the 5th, 8th, and 14th Amendments to the United States Constitution and Florida's constitutional statutes. And so that's what they want, okay? We understand that. This is, again, they've got legal argument for 13 pages, okay? So motion for transcript of grand jury proceeding. And then we've got, of course, we recently discussed this on a members-only stream, if you remember, if you were there, that Stephan Sterns is doing a lot to try to get the death penalty off the table, of course. Of course, his defense is trying their best because they are fighting for his life. Motion to preclude the death penalty as a sentencing option. That's why I feel like poke. Hey, state, you want to give us a plea deal there or what? Comes now the defendant through the undersigned counsel and pursuant to the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and all these articles and all of that. Death, they say, death is different. 1. Stephan Sterns has been indicted by the state for first-degree murder. 2. The state is seeking the death penalty. The 8th Amendment to the United States Constitution requires a greater degree of accuracy and fact-finding than would be true in a non-capital case. I mean, it is a very serious matter. We don't have the death penalty in South Africa or in Europe, in Switzerland. We don't have it. So I can only imagine, defense attorney, imagine being his defense attorney. That's a lot of pressure. That is a lot of pressure. Tom says, please tell me this trial is televised. I don't know. I would, if I had to guess, and I'm just guessing, I don't think the February one, the CSAM sexual abuse trial will be streamed, but maybe I hope that the first degree murder one will be. Heaven reigns. Thank you so much. Do you guys remember there was a man, we listened to his audio interview, okay? And he's an honorary Grizzly because he saw something and said something which led to the police finding Maddie's body. Well, he emailed and he said thank you to all of us for being so kind and for listening to his whole interview and calling him an honorary Grizzly and for all the nice comments that you guys left. So I mustn't forget to tell you that. So just wanted to pass that along. Okay, so death is different. That's what they said, right? So the state's seeking the death penalty, and they say, obviously, they don't want that. So here they say the right to life is a fundamental right. Yeah, that Maddie doesn't have anymore. Okay, is a fundamental right which must be subject to at least the same constitutional protections as the right to vote. The state must establish safeguards to ensure that it does not treat its citizens in a disparate and arbitrary manner with respect to their lives. Yeah. If anything, the courts must require more safeguards to ensure the equal treatment of all persons in the context of the death penalty prosecutions than in that of an election recount. And so they keep going about why obviously they want the death penalty off the table. We understand that, right? I mean, obviously they would be fighting for that here as well. Motion to prohibit. So the first one was motion to preclude, and then motion to prohibit death as a possible penalty. And again, the defendant, through counsel, moves this court to enter an order excluding death as a possible penalty because selecting a jury based on their opinions about the death penalty, death qualifying, will violate Stephan Sterns' right to a jury and due process of law. It's widely recognized that the process of selecting a jury in a case where the state is seeking the death penalty has an impact on diversity of the jury and juror attitudes. Jurors are excused either by cause, challenge, or preemptory challenge because of their opinions about the death penalty. But yes, they have to make sure they can pick jurors who will say that if it comes to that, they will be okay voting for that, right? Anna Carlson, thank you for being a member for 21 months. You said, how the heck dares he? Yeah. You know, he's just the forever victim. We've seen that. Remember his interviews? Oh my word. Stephan Sterns is like always the victim. And it's just horrible because he's not. And definitely not in this case. Like Madeline Soto is the victim. My goodness. So here they said, Stephan Sterns has a right to an impartial and fair cross-section of the community in his veneer under both Florida and all of this law. Okay? I think lawyers would love to read this. So if you don't have the documents, I'm going to be posting on Patreon right afterwards, right? Here they said B, death qualifying a jury prevents a representative cross-section of the community from serving on Mr. Sterns' jury. I think they'll be okay picking a jury. What do you think? I mean, it is a high-profile case. Don't know where all they'll pick them from. But yes, that's what's on there. And then if we look at this one, motion in eliminate to prohibit reference during trial testimony to the victim's murder or to the murder scene. Oh no. No, they're not allowed to say that either. I can hear objections. I can hear them already. It's as if we're in the courtroom. Objection from the defense, right? Carol Hearn says, bruh, what about Maddie's rights? So comes now the defendant, Stephan Sterns, by and through the undersigned attorney, pursuant to his right of due process, as guaranteed by the 5th and 14th Amendments of the United States Constitution, as well as Article 1, Section 9 of the Florida Constitution, by and through undersigned attorney and all of that, okay? So as grounds in support of his motion, the defendant would show the court as follows. 1. Mr. Sterns is charged by indictment with first-degree murder. 2. The state filed a notice of intent to seek the death penalty on June 7th of 2024. And 3, a court's duty to search for constitutional error with painstaking care is never more exacting than it is in a capital case. That I understand as well. And so they say the defense objects to any witness reference to murder or the murder scene. The proper terminology that ought to be used is homicide. So the state will have to brief all of their witnesses. They've been carrying out lots of depositions. The names are out there. I just don't want to put the names out there. They're out there. It's public record, but I'm just not just going to just go over that right now. I think everybody must be stressed enough as it is being called up to testify in this trial. Can you imagine? So, yeah. Okay, none of the witnesses, they'll have to be briefed if the judge obviously grants this motion that they may not reference murder or the murder scene. The proper terminology that ought to be used instead is homicide. As Florida's 2nd DCA has noted, in common parlance, homicide means a killing of a human being through human agency. The legal meaning of homicide is no different. The legal term for killing a human being, whether lawfully or unlawfully, is homicide. There's no crime of homicide. The existence of the legal categories of excusable homicide and justifiable homicide makes clear that the term homicide does not denote criminality. All right, in that vein, it is error for a trial court to refer to a homicide as a murder in the jury instruction of premeditation, because it can be construed as an impermissible comment on the evidence. The defense objects to any use of the word murder instead of homicide during witness testimony. The defense respectfully requests the Assistant State Attorney instructs witnesses to use the term homicide rather than the word murder. Wherefore, the defendant requests this honorable grant this motion to prohibit reference during trial testimony to the victim's murder or to the murder scene. Wow. Kelly D says, best 14 months. It's a good thing I own my own company and work from home. I can be easily distracted by Grizzly True Crime, the cats and Mr. Grizzly and all. Oh, thank you so much. And happy Grizzlyversary. Emily Toombs says, oh, now you can't say murder? Word police? Can't say it. Well, if the judge grants it. The judge still has to decide on every one of these. He's going to, he or she, I think it's a male judge, is going to be, I think it's Keith Karsten actually, is going to be kept busy for a while with all these motions, right? Yeah, Stephan says, so they have to say homicide scene. Wow, I mean, to me, that sounds more professional. Yeah, say that. I'm sure everyone will still understand what it means. Mariella Mendez said, serious eye rolling, right? Now, this next one is a motion to preclude submission of the indictment in any form to the jury. We've seen trials before where they asked for the PCA or the indictment in deliberations, and in one or two of the trials that we've watched together, they said that they can't have a copy of that, you know, because it's not evidence, it's allegations. So I understand this as well then, but I'm like, oh, you don't want that in either, right? Okay, so some people are asking if Jen Soto will be present at the CSAM trial, the February trial. I don't know. We'll have to wait and see. I wonder. I'm sure she would kind of have to be, but then again, who knows, right? Okay, so they want to preclude submission of the indictment in any form to the jury. Comes now Stephan Sterns through undersigned counsel pursuant to the 5th, 6th, and all of that. The defendant states, on April 24th of 2024, the defendant was indicted for first-degree murder. The trial court in this course of jury selection references to the indictment generally and on occasion reads from it. This is not necessary. I like that. This is not necessary. You do not have to show them that indictment. They say it is prejudicial. There's no need to reference the indictment or the process of findings of the grand jury. Moreover, the Eighth Amendment requires a greater degree of accuracy and procedural safeguards than would be true in a non-capital case. Don't let them catch wind of that indictment because it's very horrifying. Can you imagine the jury that will be part of this CSAM sexual abuse trial? I mean, they can't unsee it either. I feel really sorry for them. I hope that they will be, I don't know, offered counseling or help or something, because it must be so unseeable, so terrible to hear about such evidence and to hear what happened to a child. Tish Pomfret said, what would we do without you? What would I do without you? You guys are the reason I'm here, right? So thank you so much. So then the trial court in the course of jury selection, did we read this one already? Wait. Yeah, we read that one. Wherefore the defendant moves to preclude any reference by the state or the court to the indictment or the findings of the grand jury. Do you think the judge is going to grant any of these? I wonder, you know. Pat Lelino said he has nerve with all of this when he decided to be judge and jury and impose the death penalty on Maddie. Where was she allowed any right to live? I know, right? Dawn Young said, by trying him for SA first, they are proving the mitigating circumstance, the aggravating circumstance. The prejudice is why it's a death penalty case, because it proves that he can't be in public with others. Yeah, he definitely shouldn't be. If we've learned anything from Naziah Harris's case, yeah, like Jarvis Butts should have never gotten out. You know, if you'd missed that case entirely, please do go check it out. So then there's motion to prohibit questioning of potential jurors as to their willingness to render a verdict for the death penalty. I think that would be important, though, for the first-degree murder trial. Normally, they would question the jury while they're selecting them to know if they would be okay with suggesting the death penalty if it gets to that, right? Thank you so much, Indy. Sharon said, can the prosecution deny a plea deal? Normally, it's the prosecution that would be offering it if they want to, if that's a strategy. They don't have to. They never have to. It would just be a strategy. And I'm wondering if that would be their strategy based on all of this, you know? So we'll have to wait and see. And some obviously don't, or they will just dig in their heels and they'll just be like, nope. And then it's up to the judge to decide on each of these motions, and then we see what happens after that. Okay, so here they say, Stephan Sterns through counsel moves this court to prohibit questioning of potential jurors as to their willingness to render a verdict for the death penalty, and in support would show, 1, Mr. Sterns is charged with first-degree murder, and the state of Florida is seeking the death penalty. 2, it is anticipated that the state will question jurors as to their willingness to render a verdict for the death penalty. This line of questioning is improper since it does not lead to proper challenges for cause or the appropriate race-neutral use of preemptory challenges. 3, Florida law provides that a juror is never required to recommend a sentence of death, irrespective of their findings on weighing aggravating and mitigating circumstances. Well, that's interesting. If that means it's always up to the judge, then okay, then I understand. Regardless of your findings in this respect, however, you are neither compelled nor required to recommend a sentence of death, is what they quote. And so they say, 4, asking a potential juror whether he or she would in fact vote for a sentence of death is impermissibly asking a jury to commit a verdict. Okay. It's not relevant to a cause challenge because the law never requires a jury to vote for the sentence of death. Some states they do. In order to constitute an appropriate challenge for cause, the potential jurors' opinions must prevent or substantially impair the performance of their duty in accordance with the instructions and oath. 5, exercising preemptory strikes against jurors who are opposed to the death penalty denies Mr. Sterns his right to a jury comprised of a fair cross-section of the community, including those who follow religious teachings opposed to the death penalty, and many people of color who are opposed to the death penalty. 6, questions concerning a juror's willingness to impose a sentence of death predisposes the juror to believe that the death penalty is the issue, not the defendant's guilt or innocence. It also predisposes a juror to believe that death is in fact the appropriate penalty. Jurors should not be asked whether they can follow the law and impose a sentence of death. Although this question on its face inquires into a juror's capacity to return a death sentence, jurors are likely to infer that a death verdict is required by the law, at least under some as yet unspecified circumstances. I do wonder, hey? Trey says hello to all of us. Hello, Trey. Indy says then he shouldn't have done those things. Liz says they will not offer him a plea. There's no reason to. The evidence against him is overwhelming. Sometimes they do if there's a death penalty on the table, you know. But I don't know. I also don't think they definitely don't need to. They definitely don't need to. I think the evidence is very strong for the state based on what the investigators found so far that we know of. So here they said, okay, as stated by one commentator, it gets the juror to think, oh, I get it. They're asking me if I can kill this guy. Yeah, I'll do that if that's what I'm supposed to do. Is that a good example? Who are they quoting there? What? Okay. So we're almost done with this one. They said death qualification may come to resemble a kind of obedience drill in which jurors feel they are voluntarily relinquishing the power to deviate from the outcome the law seems to favor. The personal characteristics of death-qualified jurors render them especially receptive to arguments that they must follow the implicit promise made to the court. Okay, and wherefore the defendant requests this court to prohibit questioning as to a juror's willingness to impose the death penalty and prohibit excusals for an unwillingness to do so, as long as the juror commits to considering the aggravating and mitigating circumstances in the determination of a penalty recommendation. Well, let's see what the judge decides on that one. We've still got a few more to go. Stephan Sterns' objections to the use of follow the law questions to rehabilitate or qualify jurors. Stephan says, our Stephan, spelled with an F, okay? There's a difference here. Doesn't matter. If you're Stephan with a PH here in chat, don't worry. You know, some people are like, oh, I can't even hear the name Stephan. But Stephan is a nice name. Stephan Sterns, not a nice guy. Okay, so Stephan said, obedience drill, give me a break. Right? Okay, so this is, through counsel, Mr. Sterns objects to the use of any follow-the-law type questions to rehabilitate or qualify biased and death verdict-prone jurors. And he moves for a court order prohibiting use of these questions. Use of this type of questioning to qualify or rehabilitate jurors has no place in capital jury selection, as made clear in Morgan versus Illinois. The defendant raises this objection under these authorities and pursuant to his rights to due process and an impartial jury and his protections against cruel and unusual punishment, which is like, yes, I get it in the court of law, but shame. Maddie, that was cruel and unusual long-term punishment. allegedly. Based on the evidence they found on his phone, sexual abuse for about 5 years. So she would have been like 8 years old. Oh man. And just the amount of photos and videos that they found on his phone. Imagine the old devices. I'm sure they have more. You know, the public doesn't know everything. As much as there's been a lot of information that has come out in this case because of Florida's Sunshine State laws. So FOIA requests have been very fruitful. Man, we're like requesting things I can't actually believe the amount that's come out to the public, right? And so, I guess it was like Sarah Boone as well. We got to see her police interviews and the body cam and all the things as well. Angela Wilder said a plea deal may spare the public from all the details and Maddie from embarrassment. That's what I'm thinking as well. You know, if the state, which normally would be obviously fighting to prosecute the defendant and also fighting for the victim, they might, that's why I'm thinking that it is a possibility, right? Still Standing said, where was the law when Madeline was given the death penalty by his hands? Yeah, exactly. I'm glad to see you're all snarky like me. Look, Debbie's just full on angry here. Debbie's like, what? Yeah, you are swearing there. So, okay, so they don't want those questions to be asked. They said Mr. Sterns states, 1, the right to have a jury make the ultimate determination of guilt has an impressive pedigree. I mean, does he really state that? Obviously, his defense is stating it, but okay, Mr. Sterns states. And is the most important element in an accused's right to a jury trial. Voir dire protects the defendant's right to an impartial jury by providing him or her with the ability to discover juror biases and prejudices. Voir dire therefore must be conducted in a way permitting counsel to determine whether a juror has beliefs or attitudes causing bias against the defendant that would deprive him or her of the right to a fair trial by impartial jury. I mean, this defense attorney, this team really has to be careful. I know it's like, can you imagine once the jury sees the evidence that they have? Can you imagine how they will feel? I don't think deliberations would be long in that case then, right? Eleni, thank you so much. Okay, so they give us more examples here. I just want to see. Yeah, that's pretty much what we're going to be reading together here. Then we've got the defendant's proposed implicit bias jury instruction. I think we've got like 2 more after this. So they've already scripted this one. Do not decide the case based on implicit biases. As we discussed in jury selection, everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes, that is, implicit biases, that we may not be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making very important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. Our system of justice is counting on you to render a fair decision based on the evidence, not on biases. So if you gag at the defendant, if you feel snarky, if you absolutely hate his guts, please put that aside and just look at the evidence. I get it, because I can only imagine what they're anticipating the jury to feel, right? Fiona says, it's my 2nd Grizzly birthday. Stephan Sterns wouldn't want to take the plea. It would admit his guilt and give the mitigation towards the death penalty in the homicide case. Thank you so much, Fiona. Yeah, I'm more saying because the 2 cases are separate but kind of attached, because if he's convicted in the February one, that'll serve as an aggravating factor for the 1st-degree murder one. So the plea deal, if no one says there's a plea deal on the table, okay, just make that clear. It's just me speculating. If the state, in response to all of this, is like, all right, here's a plea deal, then it would be for all of it together, you know what I mean? To say, well, okay, we'll take the death penalty off the table if he pleads guilty to all of these things, which could save his ass a little bit in prison. You know what I mean? Can you imagine, if convicted, what his life in prison will be like once they know what he's done to a child or to children? I don't know what other evidence will still even come out, right? Okay, so there we go. We saw that one. And then it says motion to declare unconstitutional facially and as applied victim vulnerable due to age, disability, or familial or custodial authority. There's a couple of typos in there. Comes now the defendant Stephan Michael Sterns by and through his undersigned attorney and requests this honorable court to enter an order declaring that, according to this, right, the jury instruction, wait, Florida statutes, okay, unconstitutional, and to preclude its application in this cause, statutes and or 6M jury instruction unconstitutional and precluding the application in this cause as grounds would state as follows. According to that, sets out the aggravating circumstances that may be considered in determining whether or not to impose the death penalty in a first-degree murder case. It provides in pertinent part aggravating circumstances. Aggravating circumstances shall be limited to the following. The victim of the capital felony was particularly vulnerable due to advanced age or disability, or because the defendant stood in a position of familial or custodial authority over the victim. This aggravating circumstance and laws of Florida, effective October 1st, 1996, will be unconstitutionally applied in a manner inconsistent with its legislative purpose. It is unconstitutionally vague and overbroad and is not capable of a constitutionally adequate narrowing construction, and as such will be applied in an arbitrary and inconsistent manner. Because this unconstitutional circumstance will be used as a basis for imposing death sentences in the state, because its use makes proportionality review arbitrary, and because its bare terms are all that are required to be read to be sentencing juries, there being no separate corresponding jury instruction that in any way narrows or explains its terms, it as a whole is unconstitutional. Kerry says, like in Audrey's murderer's case plea deal. Yes, Audrey Cunningham's killer, Don Stephen McDougal, was offered a plea deal. Even though there was like a little clause that said they weren't actually going to pursue the death penalty anyway, but he took the plea deal thinking that it's because he's going to avoid the death penalty. Like if you read that, it's on my community page, which is now renamed to Posts. So if you're looking for it, it's called Posts now. Hope you find it. But if you just scroll down a bit, there's the update on Audrey Cunningham's case as well. Pernil says, paging Judge Gull. For a little bit of deny, yeah. Okay, so again, this is 17 pages of them arguing why this should be. To declare these the aggravating factors, they obviously have a problem with how it's worded and how it's going to be said and all of that. So, yes. Wherefore, we love the conclusion. The above-named defendant respectfully requests this honorable court to enter an order declaring that according to those codes, unconstitutional and preclude the application at bar. But, you know, you want them to leave out the aggravating factors as well? So, don't vilify Stephan Sterns. Don't sympathize with the victim. Do not show the jury the indictment, okay? No victim impact statements. Let Stephan Sterns' family argue about how much him being sentenced to death will impact them, all right? And also, do not present your aggravating factors. If we were to summarize everything they're asking for right now. Now, here's another one. Let's just see. I just want to scroll like this. Yeah, there's only, oh man. I'm like, there's only two more. There's a few more. I think the next one is a case summary. Motion to declare Florida statute unconstitutional and to bar states' use of hearsay evidence at penalty phase. Emily says, are you going to post these to Patreon? Yeah, he's in protective custody. Yes, I'm going to post these on a public Patreon post. So my latest post that told everyone about this live stream, there's already almost 8,000 Grizzly patrons on the free tier. And then you're going to get your notifications, okay? So go there after the stream. I will upload these documents there, okay? So that you can read through all of this yourself if you want to. Now, motion to declare. Okay, so comes now the defendant, Stephan Sterns. Let's just see. They said the defense argues in authorizing the state's use of hearsay, the statute is unconstitutional, and as grounds for this motion would state as follows. 1, this is a capital case in which the prosecution asked this court to impose the death penalty. Hence, the heightened standards of due process apply. Totally understandable. 2, an unconstitutional death penalty statute and use of hearsay by the state at capital sentencing violates all these articles. So that's even just like preempting that as well. They're making sure that they are prepared for the absolute worst, which does also say a lot. I know defense attorneys are always prepared for the absolute worst and they're there to defend their client, but this really feels like, oh, you are ready for, yeah, literally the absolute worst, which could be the death penalty, right? Okay, so again, examples. It's 5 pages of just examples, citing court cases of why they are making this argument. Wherefore, the above-named defendant, Stephan Sterns, respectfully moves this honourable court to enter an order declaring section unconstitutional and barring the state's use of hearsay at penalty phase or granting such other relief as may be appropriate. Okay, so this trigger warning, firstly, let's just put this trigger warning up here. Because just look at the list of charges just for his February trial. Just look at this horrific list of charges. And remember they said each charge represents like 10 or more images or videos. Oh my goodness. Okay, so you can see all of that. This is the CSAM, possession of the CSAM child essay material. Those words I shouldn't be saying too much on YouTube, and then also these. It's just terrible. Okay, so we've got that, and I've shown you this as well. So pre-trial, 12th of Feb 2025, jury trial 24th of Feb 2025. Judge is Keith Karsten, courtroom 4F. Okay, so we've got that. Then there's a motion for separate juries for each phase of the trial. Okay. So the defendant, by and through undersigned counsel, moves that this court to preclude death qualification for jurors involved in phase 1 of the trial and have 2 separate juries for both guilt, innocence, and penalty phase. I don't know if I've ever seen that. Have you seen that? Ooh, yeah, that's true. Law 3440 says Florida only needs 8 jurors to vote for the death penalty. It does not have to be unanimous. Right, and if it's a capital punishment case, then they would have normally 12 jurors, whereas other cases would be 6, like we've seen in some of the Florida trials. So they might have 12, but only 8 of them need to vote for the death penalty. It doesn't have to be unanimous. Interesting. Okay, and so they said motion for separate juries. Ooh, wow. Okay, the defendant requested this court recede from Lockhart versus McCree as part of its ongoing history-based re-evaluation of the 6th Amendment's guarantee trial by jury. And then they obviously, for 8 pages, motivate that with a lot of cases that they're citing. Wherefore, the defendant requests this motion be granted. I don't know if that one will be. Will it? Minty Freight said, I've never seen these requests. Mary said something interesting up there. Wait, where is it? Mary said, did you see the argument that just came out against the death penalty for Stephan Sterns due to his TBI and insurance dollars paid out $20,000 to his family? I know about his traumatic brain injury, and I know about the insurance dollars paid out. I don't know if I've seen the argument about being against the death penalty for that. I'm not sure if I've seen that one. There's just so many, right? I don't doubt it. There's probably going to be another 20, right? There's probably going to be another 20. By the time we're done with this stream, there'll probably be another 20 motions of like, oh wow, okay. So this one is it this? No, motion requesting special precautions for voir dire. Stephan Sterns submits this motion, requests the court for methods and means by which the voir dire in the upcoming trial may be conducted lawfully, fairly, and efficiently, while also eliciting all necessary information to determine whether potential jurors harbor disqualifying prejudice so that the counsel can intelligently exercise preemptory challenges, including permitting individual and sequestered voir dire relating to pretrial publicity. But that's obvious. They have to pick a fair jury, you know. So special precautions. Case law studies experience has shown that the process of capital voir dire can be detrimental to the ability of counsel and the court to obtain all necessary information. Moreover, it may incline juries toward conviction and a sentence of death. For these reasons, we ask the court to take precautions at Stephan Sterns' trial to ensure the fairness of the process. Avoiding processing effects. And here they're just going to go on and on about this, of course. Again, if you want to read every word, I will provide the document. Learn before instructing. Broad leeway to inquire about publicity. But this is obvious. This one is like common sense here. You got to pick a fair jury, right? Okay, and then this one. Motion to bar the state from using preemptory challenges to exclude prospective jurors who express religious or equivalent reservations about the death penalty, but who cannot be excused for cause. Shaniqua, thank you so much. Yeah, look, Shaniqua is also angry. Okay, so comes now the defendant, Stephan Sterns, by and through undersigned counsel, pursuant to the 6th, 8th, and 14th Amendments. We've got all of these. As grounds for this motion, the defense states Stephan Sterns is charged with capital homicide. Yeah, they don't want to say murder anymore. Homicide. and the state of Florida is seeking the death penalty. Since this is a capital prosecution, exacting standards must be met to ensure that it's fair, of course, right? And so the state's use of preemptory challenges to exclude potential jurors with religious or equivalent reservations about the death penalty would violate the potential jurors' rights under the first. So they want, just let all of them in and let the jurors decide. Even if, like, 10 of them don't think the death penalty is appropriate. Obviously, the defense would want that, right? In a death penalty case. So, like, just let them all in. Don't even ask them about that. Merrily said, so happy to be here with all you Grizzlies. With all of those charges, how could they possibly defend him? That's why I think we're seeing also all these motions. It must be so incredibly difficult, especially for the first trial, to defend him, which would then, if convicted, and he could face multiple life sentences and even 5 years per picture, and they have over 1,500. Wow, he could already just for February's trial spend the rest of his life in prison if convicted. But if convicted, that becomes an aggravating factor for the next trial. So it really starts stacking. That Mickey said, honestly, this is the defense's last minute desperate attempt by throwing spaghetti at the wall. That was my take on it too when I read all of this. I'm like, oh my goodness. Indy Isham said the indictment is a legal document, part of the legal process. Yes, so we understand why they want everyone in there. And I think actually that's the final document. So if you guys are only joining now and you're wondering what are we looking at, I hope to never bore you. Okay, I just wanted to show you these updates because it's just voluminous. This one, when I saw this, I'm like, really? This is the one we started with, okay? Motion to exclude evidence or argument designed to create sympathy for the deceased or vilify Mr. Sterns. They don't want that. I understand the defense doesn't want that. I'm pretty sure the state does though, right? Pernille says collective Grizzly eye roll. Yes, indeed. Elizabeth says denied, 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 denied. And take a look at your self-defense. Or Stephan Sterns, take a look at yourself in your plastic mirror in your cell, right? That baby boy, my word. I think I told you last time that when I ordered his jail records to see his commissary and all of that, remember he was ordering that root beer candy? And then the next time I ordered another round of his requested, not ordered, I make it sound like a damn menu. When I requested his commissary records, then it said the root beer candy was suddenly what was the word that they used? It was like an invalid or prohibited item. I'm like, oh damn, he couldn't get his root beer candy anymore. I see Grizzly Cat is sending me a document here. So just hold on 1 second. What is that? There's another document. Oh no, am I going to get 10 more documents? When Grizzly Cat starts sending me a document in this case, I'm like, oh, there are going to be 20 more. Let's quickly look at this one together. What is it? Motion for closure of all pre-trial proceedings. Wait, it's a new document, okay? So it's like breaking news. It's brand new. Okay, anyway, so let's look. State of Florida versus Stephan Michael Sterns. Motion for closure of all pre-trial proceedings. Okay. Stephan Sterns, through counsel pursuant to the 5th, 6th, 8th, 14th Amendments of the United States Constitution and Article of the Florida Constitution, moves this court to enter an order closing all pretrial proceedings in this cause to the press and the public. Oh, damn, even to the public. Okay. Grounds in support of motion. Mr. Sterns is charged with first-degree murder. I thought you want to say homicide defense, huh? The state of Florida has filed notice of its intent to seek the death penalty in the event of a conviction of first-degree murder. This case has been the subject of unprecedented and highly prejudicial publicity. Okay, I'm not going to lie, probably. I think the whole world knows about it, at least in true crime. But never forget, if you walked around, if you live in Florida and ask people if they know about this case, many probably won't. That's always shocking, you know. We're in it, we're looking at everything in this case, but it's like, huh. Some people obviously won't know and they'll be able to pick a fair jury. But they say this case has been the subject of unprecedented and highly prejudicial publicity and media attention in Osceola County, adjacent areas of Osceola County, and a majority of the state of Florida and outside. Didn't even mention Switzerland, this guy. At every court proceeding, however minor or inconsequential, there has been extensive coverage by the press as well as social media users. Here we go. On YouTube, TikTok, Twitter, now called X, and Facebook. Okay, that's true. It's very true. Zero patience. Thank you so much. You said, love being a grizzly. I might be addicted. Oh, a happy 1 year. Now, they said it is anticipated that the press will continue to be active and aggressive in the coverage of all events and proceedings in this case. Okay, yes, it's not like I'm proving otherwise. We are here with our snarky pants on. 5. Counsel for Mr. Sterns intends to pursue numerous pretrial motions of evidentiary and legal significance to the preservation of Mr. Sterns' right to a fair trial. The types of motions Mr. Sterns expects to pursue once discovery is completed include, but are not limited to, motions to suppress, motions to exclude evidence, motions in limine of irrelevant and prejudicial testimony and evidence, the constitutionality of the death penalty, the appropriateness of the death penalty under the proportionality scheme of Florida, and the United States. What are we hearing here? We're hearing no cameras. That's what I can hear. I'm looking, I'm interpreting. Oh, you don't want cameras in this courtroom. I understand. So, just a crazy Jen says, known YouTuber. Okay, yeah, and snarky, says Stephan. So here they said, okay, interesting, yes. So Florida and the United States Supreme Courts and many other motions, which could include a motion for a change of venue if the media coverage of this case continues as it has, so that Mr. Sterns cannot receive a fair trial in Osceola County and most of the state of Florida. Oh, damn. Okay, you want to move it to Switzerland? These motions will require testimony and discussion of the evidence in this case prior to trial. In some instances, this could involve evidence which may later be found to be inadmissible. Included in these discussions of Mr. Sterns' evidence will be Mr. Sterns' statements to the police. Yeah, we've heard a lot of that. Okay, the medical examiner's findings and potentially discussions of evidence related to the statements from minor children. Shame. I just feel so sorry for Maddie's friends. If you ever wonder why don't I play those interviews, I just don't want to. I feel so sorry for them. Like all these little girls who were friends with Maddie who are now going to have to testify at this trial. Can you imagine? Shame, the trauma, oh my goodness. So anyway, public dissemination of these items of evidence will prevent Mr. Sterns from receiving a fair trial. Public discussion in the press in the form of news stories, polls, letters to editors and editorials will lead to an environment which will preclude Mr. Sterns from being afforded a fair trial in Osceola County and most of the state of Florida. Counsel for Mr. Sterns feels there is no suitable alternative measure to protect Mr. Sterns' right to a fair trial under the United States and Florida constitutions other than closure of all pretrial hearings. I mean, I can't blame them. I understand. Wherefore, Mr. Sterns moves this court to enter an order closing all pretrial proceedings, or in the alternative, all pretrial evidentiary hearings, or enter any other orders which the court believes will ensure Mr. Sterns' right to a fair trial. Okay, so yeah, I don't think there's going to be cameras for the pretrial or the February trial, in my opinion, based on the charges. Also, because if there was, it depends. You know, how responsible will people be with covering that? Never mind, I don't think you could even stream all of that type of stuff on YouTube, and I wouldn't think that's good. You know, I don't know how else to say it, but don't feed the pedos, you know what I mean? Don't feed them. We don't need to give them that content online. So I hope it's private. I really hope the first trial is actually no cameras. The next one, though, the murder charge, yeah, I hope that one will be publicized, so that we can learn what actually happened, you know? Okay, so that Mickey said, I agree that they cannot record the minors, but the rest is fair game. That as well. Sometimes they could do that as well. Just make sure they either don't show it. We saw that in Jarvis Butts' preliminary hearing. They didn't stream the minors' testimonies, right? Or they'll just turn the cameras away, if so as well. Pernille said Sterns has a public defender. Yes, Sterns has a public defender. And, ooh, can you imagine if they stream it, the entire prison will be watching? Oh, yes, that as well. Lee T said pretrial hearings is one thing, but Florida won't ban the whole trial, in my opinion. I don't know. Have you ever watched a CSAM trial when they say all those things? And, ooh, that'll be just so tricky. Oh, my goodness. Shame. Okay, yeah. Deb says, yes, G cameras in the homicide trial. So, again, thank you to Grizzly Cat. Thank you so much for this latest document. Is there anything else? I don't know, that's it for now. I really appreciate that. I will put Grizzly Cat's Buy Me a Coffee link in the description box as well. If you want to find my coffee link or the mod's coffee link, that is also on, it's shared in the chat or on grizzlytruecrime.com. So Alice says, when is the trial going to start? Well, if you look at the beginning of the stream, we did some homework there. And I will just quickly, very quickly show you this again. We recapped this, okay? And then we looked at what his charges are, as well as when is the trial. And again, I'm going to say, put this, you know, even though it's soon, for me it's soon in pencil because it could change. But the pre-trial is February 12th, and the trial starts on February 24th, supposedly for now, of 2025. So that's pretty soon. And that's the 60 charges of sexual abuse and CSAM related charges. Okay, so that's the first one coming up. The next one after that is the pre-trial September 10th of 2025, and the murder trial will be starting supposedly on September 22nd of 2025, right? So that's what we have. And if you missed, what his charges are and all of this, then you can just check out the beginning of the stream, and then you'll be all caught up because we went over all of this. And you might also want to check out this part where I read a little bit about Maddie, which is actually very beautifully written by her father, Tyler Wallace. Okay, everyone, so do we feel a little bit caught up now? I mean, again, by tomorrow, there'll probably be another 20 documents. I don't know if I'll go through all of them like that. I just want to show you what's happening in this case, that the wheels are turning and they are heading towards this trial in February. But let's see if it gets delayed, if something changes. That I will definitely keep you posted on. Places to look, YouTube Shorts. Check out my YouTube Shorts, or the community tab, which is now renamed to Posts. Or maybe we meet again for a live stream when there's more information that we can talk about that would be important. Okay, so Eagle Eye said if Jen Soto does not show up for her daughter's trial due to idle threats, I will be disgusted. I'm sure the Sterns are mortified, yet they will be there. That's going to be interesting to see, or to know, or to hear who was there, who wasn't there, all of that, right? So, my goodness, I just had a glance now and I see there's 5,300 people here. Thank you so much all for being here. Please like and share so others can also learn about these updates. And yes, please know, I have not forgotten about this case. I do not forget about the cases I cover. I'm keeping a close eye, and I will update you as soon as there's anything to update you with again. All right, everyone, stay safe, and I'll see you again very soon. Go now to Patreon, right? Patreon.com/GrizzlyTrueCrime. The latest post, I'm going to be attaching those documents to that post so that you can download them and read them yourself as well. Thank you, everyone. Bye.